Leo here with an event video on Fred Brunner versus Melanie Sterling, a case involving a romantic relationship between an Arkansas businessman and a Las Vegas dancer. The plaintiff claims to have been defrauded out of millions of dollars during a decade-long relationship and filed suit here in Nevada after an Arkansas judge rejected the lawsuit without prejudice. He claims to have met the dancer at a club as he progressed through his divorce proceedings, and that he gave financial support to Ms. Sterling out of appreciation for her emotional support under the belief that she was in an exclusive relationship with him. The defendant claims the lawsuit is a sour grape situation, and that Mr. Brunner may have been generous with his wealth, but he was not naive, and that she believed from the start that he was not the monogamous type. She added that Mr. Brunner is an extremely wealthy man who is used to getting what he wants, and that he only filed a lawsuit after she refused to return to him despite his begging and pleading. The parties were never married, never engaged, and never lived in the same home. District Court Judge Mary K. Holtis is allowing comprehensive electronic coverage of the proceedings, the first hearing of which was already recorded and will publish shortly. The plaintiff is represented by Aaron Maurice. The defendant is represented by James M. Jimerson. You can keep up to date with our coverage schedule by visiting the media tab at ournevadajudges.com. You can post any questions you have down in the comments below or send us an email at media@ournevadajudges.com.
In 2014, a married man walked into a Las Vegas strip club, walked out with a new girlfriend, and now he gets married to tell this court that he's the victim. That is nonsense. This is nothing but a case of sour grapes between plaintiff Mr. Brunner and my client Ms. Sterling, who had been in a relationship from approximately 2014 through 2024. After those 10 years, the relationship was at a crossroads. And in the end, Ms. Sterling chose to take the proverbial Saturday morning leap and ended the relationship. What did Mr. Brunner do in return? He sued Ms. Sterling, first in Arkansas, and when that was dismissed for formal nonconvenience, here in Nevada.
By far the case that is that deals with this issue of a confidential relationship in Nevada is Perry versus Jordan. That's 900 Pacific 2nd, 335. It's a 1995 Nevada Supreme Court case. There the court says, quote, persuasive authority suggests that a confidential relationship may arise by reason of kinship or professional business or social relationships between the parties. Think about that. We're not talking about a difference between, this is not a situation where you have a doctor getting sued by a patient for inappropriate relations. We are now talking about what it means to have a confidential relationship. And this is the Nevada Supreme Court recognizing that these relationships may arise, quote, by reason of kinship or professional business or social relationship between the parties. Such relationship exists when one party gains the confidence of the other and purports to act or advise with the other's interest in mind. It may exist, although there is no fiduciary